Hello, I am Francisco-José Quintana. I'm Max Weber Fellow at the European University Institute, and it is a privilege to be sitting next to my fellow Max Weber Fellow, Gabriele Wadlig, to speak to Professor Fleur Jones, who's visiting us this week at the UI and the Max Weber program. Professor Jones is professor of law at the University of New South Wales, and among her many influential works is the very recent Help, published by OUP last year, on which she discusses the rise of digital humanitarianism and its implications for international law and politics, and which I think will be at the center of our conversation today. So welcome to the UI, and thank you for joining us.
Thank you, Francisco. It's a pleasure to be here.
Before we get into more detail, I wanted to ask you a very simple question. Why did you become an academic, and how did you end up in international law as a discipline?
Yeah, it's interesting to reflect back and reconstruct one's journey to this current place. So I think I became an academic because I enjoy universities. I like them as workplaces. I like them as places to inhabit. I like reading and writing. And I think these are the space of the university is a space worth defending, I suppose. It holds open certain possibilities of asking certain questions that are more difficult to ask in other settings, and so I'm invested in that. And so becoming an academic for me, was a possibility of inhabiting those spaces and also contributing to their continued viability. And I came to international law relatively late. I came to law, really committed to law as a field, relatively late in my undergraduate studies. And I think what led me there was very much experiences of interactions with certain teachers and certain classroom conversations with my peers. There were, in the last few years of my undergraduate education, there were some teachers that were absolutely formative in terms of identifying international law as an area of scholarship that was vibrant, fascinating, high stakes, urgent somehow. And, there are people that you would recognise who taught me in those years, Gary Simpson, Wayne Morgan, Penny Matthew, and also people who I heard speak around that time, Deborah Cass, Hilary Charlesworth, and Orford. Tim McCormack was another of my teachers. So it was really about the impact of those teachers, I think, in the last few years of my undergraduate education, whereas I'd previously been relatively disengaged with the prospect of being a lawyer, or had sort of consigned the discipline to a space in my mind that didn't seem very politically important. I associated it in my early years with kind of people who wanted to go and make money and so forth. So, I think teaching and being in certain classroom discussions with peers was what led me to international law. And that experience continued into my graduate school experience as well, in which teachers remained key.
Thank you.
No follow-up? Okay, thank you very much. So, I want to ask you a bit about the book and your most recent work on digital humanitarianism. So in the book, you discuss how it is transforming international law and politics. And you've said that international law is already different yesterday in the Max Weber masterclass. So my question seeks to, try to reintroduce this into your work on theory, or it's very much in theory, but historiography. I had recently read your chapter in the contingency volume. And so I was thinking, well, how does this happen, right? And that obeys to my interest in international legal change. So I wanted to ask you, well, what processes of legal contingency and legal necessity enabled the rise of digital humanitarianism in global governance? If you could illuminate us on that.
It's a great question, Francisco, and one that could have a very long answer, but let me try and be brief. I mean, I think of, probably like you, necessitarian thinking, necessity in terms of guided by Roberto Unger, that being the belief that the current configuration of the social, political, economic and legal world is a kind of natural result of the course of history and an unavoidable result. So that's what I think of in terms of necessitarian thinking. And that has played a very significant role in the turn to digital technology in international humanitarian work that I've been studying. One can think of the investment of the market with certain properties. So the idea that that the market is naturally and necessarily understood and identified with contractualism, entrepreneurship, with an orientation towards exchange. So the necessity that is a space that needs to be promoted and embraced as a sphere of freedom and value and possibility is key to this. Also, the necessity of sort of orienting public actors towards that terrain and its identification with efficiency, with creativity, with innovation. So that's very much part of this story as well. So often the turn to digital technology is associated with a promise that the international organizations, for instance, and governments that are making that turn will thereby be made more efficient, or demonstrate their innovativeness, their entrepreneurship. And so it's the necessitarian thinking around the association of those things with certain types of practice, certain technologies is key to that turn. At the same time, what I try to enliven in the book very much is a sense that of the contingency of struggle over this, that there is very much an active struggle around the process of making knowledge using digital tools, the process of making certain forms of knowledge usable and actionable is something that people are struggling over and contesting. And so the contingency of that is something that is very much part of the story of the book as well.
Thank you so much.
Yeah, I actually think you kind of already gave a little bit of a hunch. I have a hunch of what your answer might be to my next question. It seems to relate to what you were just saying. But maybe you can give us a little bit of talk a little bit about your academic trajectory, because you wrote about a diverse array of things, from finance, non-legality, infra-legality, and algorithms, data, and that. And I was wondering whether you could, where do you see the links between these issues, and how did you practically, how did you stumble upon them, or how did you find your topics? How do you go about this?
Yeah, I mean, again, this is sort of a process of subsequent reconstruction. So I'm working in the tradition of the generalist international lawyer, and there's a sort of pathway for that. Although I suppose specialization is becoming increasingly the norm. And so insofar as I have specialized, I've been particularly interested in the kind of edges of legal normativity, the ways in which international law sustains its claim to law when the legal practices, legal knowledge passes out of its typical forms into other materializations, into other forms of knowledge, and then re-enters so I'm interested in this sort of that's where I use the term infra-legality, the idea of a legality that is sustained within legal practice, but on its kind of edges, or through the movement to the edge and back in. And that's kind of sounds very abstract, but it's involved the study of legal knowledge creation in spaces that aren't typically understood as spaces of legal knowledge creation, like the torture room or the counterterrorism detention site. Or so I was sort of trying to draw these to the centre of the study of law as places where law gets made in very significant ways, rather than spaces where that are only understood in terms of the breaking of law or the negation of law. So centering spaces that are typically understood as anti-law has been key to this, the various things I've studied. There is a connection between, I mean, in particular, in the first chapter of the book, I tell the story of the connection between the work that I've done on finance and dam development, collaborative work I've done on dam development in the Mekong, and how that led to the study of particular algorithms being used in financial modelling. And again, that started within a sense that in the work of cross-border finance that I worked in as a legal practitioner, a powerful normative force at work in some of that, some of the deals in question was the financial model. That certain contractual terms were directly keyed off aspects of the financial model, and the financial model sort of exerted a talismanic force over the negotiation of the legal agreements and in question, the drafting of the legal agreements in question. So I was interested in investigating financial modelling as a practice of lawmaking. So that was the initial kind of centering of something that's typically seen as non-law or anti-law. And then investigating those financial models led me to explore the work of a particular class of algorithms known as Monte Carlo algorithms, which are one of the ways in which financial modelers incorporate uncertainty into long-term financial models designed to model the financial scenario of a, say, 30-year development project, infrastructure project. And so trying to understand how they operated and the normative force that the lawmaking work that they were doing led to this body of work on digital technology, which has led to this book.
Thank you.
It's fascinating to hear about your trajectory in that context, because I always find super interesting to see how our early experiences then shape so much of our intellectual careers. So I'm from Argentina, and I was talking to a Colombian friend, and we realized that his whole intellectual concerns were marked by his generations, and he's a bit older than me, and his country. So towards human rights, and I guess I realized, well, I was. So my political coming of age was the 2001 crisis in Argentina. So in a sense, it's all about who is governing it, and that took some time to get shaped. That was, I guess, the concern. I've been trying to do that. We've had the privilege of having you for 2 days now. So I'm a meditative rhythm around these questions, but if we want to understand, or if I want to understand how the possibilities of actually having some sort of national authority, then the tools that we have are rather limited, because the most well-known or most influential intellectual legal trajectories focus on or describe the possibilities of engaging with a world that's no longer our world, right? So there were some tools for contestation, certainly in Latin American international legal thought. So, but those do not seem to be possible in the digital age. So I wanted to ask you if you had any ideas on well, you do have actually. So I want you to ask you to expand on this fascinating approach that you take towards illuminating these new techniques and possibilities of critique and contestation that are being made possible by the interfaces and the new, if one can call that, digital age.
Yeah, so I could have written a whole book about all the ways in which the work that international lawyers do in the international humanitarian field, broadly understood, is constrained and circumscribed and made more difficult or narrowed by the incursion of digital technology and the use of various sort of decision support tools in this setting. But I wanted to proceed, as you intimate, in a slightly different direction that took seriously the fact that, yes, when an institution an international humanitarian actor decides to invest in creating a digital tool and try and encourage its staff and various constituencies to engage with that tool, it does direct their attention in certain ways and away from others. There is very significant costs associated with that, but also that there was a sense in which the story of the effects of digital technology in international legal work remained to be told, and that it was being told in practice. That I wanted to take seriously the idea that those who were trying to explore the use of new decision support tools in international humanitarian work were engaged in a kind of struggle over this, that they didn't see it as wholly determined by the technology, that they were concerned by its implications for their work. I wanted to have those voices of kind of concern and struggle and angst, if you like, alive in the book, but also to suggest that international lawyers' techniques have something to offer that struggle. So one example I spoke about yesterday was the use of a digital mapping technology to inform the evidence base for contesting a decision in a particular jurisdiction in Ecuador around the allocation of rights to extract resources and the efforts of Warani people, Indigenous nations, to contest those permissions to extract resources in their traditional lands. And in that context, what I was suggesting was that these communities and their allies were able to leverage the possibilities of digital technology to render legible the range of legal attachments and relationships to the territory that would otherwise potentially not have been legible to the courts in question. And the very fact that the digital technologies were discontinuous with the way of making knowledge, the way that they were making cartographic knowledge was discontinuous with the way in which knowledge had been made previously in previous court proceedings, was the source of some possibility. So in many ways, that was utilising a range of legal techniques to contest on procedural grounds certain decisions made by a state, and the relief delivered was procedural. So there's something quite familiar about the form of contestation, and it has its limits. But the evidence base in question that was put forward through the making over an extended period, this community's use of the digital mapping technologies to create new maps of the territory, I guess allowed a point of entry that might not otherwise have been possible. So the book tries to describe a number of instances in which openings arise from the disjunction between knowledge practices with which lawyers are very familiar and knowledge practices informed by digital technology, and shows how different actors enter those spaces. Now, of course, among the actors entering those spaces are very powerful, one could say dominant actors, and that story of the role of large corporations, key players in the technology space, is part of the story of the book. But I also wanted to present stories that indicated the extent to which those corporations were still that they weren't wholly covering the field. That the story of the move of players like Google, Hewlett-Packard, Microsoft into international humanitarian work hadn't reached its end.
Thank you so much.
Well, considering that you have been doing cutting-edge research, being really on the avant-garde of critical international law scholarship, I was wondering, what are you thinking about now? What are your future projects, or what is your current project? And what do you think are urgent questions or is urgent for international law scholars to think about in 2024? And more specifically, if I may ask you, if you imagine PhD students maybe listening to this, maybe wandering being in search of a topic, what would be like, let's say 3 or 5 PhD thesis, 5 issues that are really ripe for engagement by international law scholars?
Well, I'm working, thanks, Gabby, for those questions. I'm working at the moment on a project that follows on from this book in some respects. So a lot of the digital interfaces that the book studied were digital interfaces designed to deal with disaster settings or emergency settings, but disaster settings, particularly associated with climate change and the increasing frequency and intensity of natural disasters. So the current work is started with an interest in a continuing interest in disasters, but particularly the role of diplomats in navigating international legal relations in the context of disasters. So my current work is on diplomatic practice and also consular practices. So that's who I've been talking with. And part of the story of contemporary diplomatic and consular practices is about the use of technology in those settings, but really that's really only a relatively small part of the story. So diplomacy and consular work is my current preoccupation. And I was intrigued by what's been common to other areas of work that I've done is an interest between the interaction between very arcane knowledge practices and professional practices and those which are identified as you say, on the cutting edge. And this is something you see in diplomacy, this long-standing practice of professional improvisation. So the diplomat, especially diplomats in smaller states, like Australia, which is the diplomats I've been mostly talking to, present themselves as professional improvisers because they're constantly being asked to do more than they think that they know how to do or have been trained to do. So they're constantly at the edge of their expertise. And in many ways, I think this is a familiar refrain in international legal work. This kind of amateurism, if you like, in international legal work has been a feature of different aspects of international law, as a number of scholars have previously shown. So that's what I'm working on now, and I could talk more about that project, but maybe I'll just wait for the work to come out to show what I'm interested in that concern. But because you've also asked this hard question of what should PhD students be thinking about now, and I mean the conversations we've had today and yesterday have convinced me of what I've always been convinced of, which connects to your point, Francisco, that I think PhD students should work on what is burning in their belly, what they feel really worried about and motivated to. And often this goes back to formative experiences of political awakening. And so I think I'm not a big fan of handing out topics for that reason, because I think it's hard to do good work when you don't really have that kind of complicated but powerful relationship to the work and its importance. So far be it from me to hand out topics, but if I were writing a PhD, I was thinking, it was nice kind of thinking about this, and so I did come up with a random assortment of things, some of which I've thought about previously and some of which I haven't. I mean, one thing I've been thinking about just recently is the question of waste and the superfluous. So old people are often among those who are characterised as superfluous, unproductive. So you could say that they belong to the sphere of superfluity in many cultural and political and legal settings. So I think the study of superfluity and what is considered extraneous or what is a byproduct, what is characterised as waste, and who is associated with the domain of waste, and how that the trade in waste, the distribution of waste is regulated, is another area that's I've previously had some opportunity to think about, but I know, and I'm aware of some interesting work in that area, but I think there's a lot more to be done in that. And I mean, what other things I've also been, I mean, in the more diplomatic work that I've been looking at, I've been interested by the efforts of a number of leaders, people like Cyril Ramaphosa, the president of South Africa, to reposition, to articulate a new politics of non-alignment, and particularly using international legal institutions to do that, intervening in these, with the proceedings in the International Court of Justice being a key example. So I'm interested in that. Seems to be an area of something worthy of attention as well. What this new politics of non-alignment might look and sound like, and how the role of international legal institutions in its articulation and negotiation. I could imagine a really interesting set of projects around that. And also, I suppose, going back to what I was earlier talking about centering practices of lawmaking and legal knowledge making that otherwise appear quite marginal. I'm interested in work on military adjacent activities. So all the regulation and governance of forms of work that are supportive of military activity. So logistics, supply lines, forms of training, status of forces agreements, all the kind of infrastructure, if I can use that word, that supports military, the military and the role of international law in sustaining that. If we're serious about dealing with violence and conflict, we can't just deal with the sort of pointy end of that, but also the various ways in which the deployment of deadly force is facilitated logistically, and the role that the way in which international law is implicated in that. And again, that's an area that I know already a lot of people are working on, but the relationship between the economy of that and the relationship between finance and military activity. There's already a lot of work on that, but I can imagine a number of further projects in that area. So yeah, as I said, these are all things that I'm interested in, but far be it from me to.
We're looking forward to your work on these topics.
Well, I'm not going to be working on all of them, but diplomacy and consular work is what I'm interested in at the moment.
Well, it's all fascinating. Yeah, you said you wouldn't give topics away, but you did. So, so I can already see the 5 applicants to the UI next year on forest management. But no, yeah, fascinating topics, and I'm particularly interested in non-alignment, as we were talking, and I was thinking, yeah, about the possibilities that the international legal or that we as international legal scholars create for new projects and new openings. And whenever, so I'm researching BRICS, and whenever I say that I'm researching BRICS, which is a new thing for me because it's through history, I feel like I have to apologize, because it's just you are seen as either too utopian or too apologist. And I mean, it seems to me that the only projects studying attempts to break the frame in international law that are allowed are those in the past, right? So new international economic order, by all means, just that you can do. BRICS you can't, even though, I mean, if you look at the new international economic order, of course you would see lots of problems that people now associate with BRICS. So BRICS is a project of the Chinese Communist Party. Well, of course, new international economic order had lots of contradictions. So I wanted to ask you about another facet of your work, which concerns, I mean, all the aspects of the so-called academic service, which you have done a lot as an editor, as a professor, now as the newly appointed dean of Sydney Law School, if we don't have to cut that out. But so no spoilers. So what could we do, or what are we doing good, or what are we doing bad, if anything, or what could we do better in terms to to allow scholars and students to develop the projects that are important to them, yeah, in international legal scholarship, if that makes sense.
It does make sense, and it connects with where we started with the question of why be an academic. I mean, I think that when I think of the work of sustaining the workplace in and engaging with practice, how we teach, how we conduct research, how we relate to colleagues, how we relate to all the people that inhabit the university space. This is very much uppermost in mind. I mean, it's not something separate to the work that I do in scholarship. And so I see, you know, this administrative role that I'll be taking up next year as a continuum of work that I've been doing in other registers. In terms of what's being done, or some of the challenges that I identify, I think obviously there are lots of variations jurisdictionally, and even within jurisdictions, different workplaces, different institutions, they're very unevenly resourced. But if I can generalize, I think it's one of the difficulties that I see recurring in many spaces is that as academics, we're increasingly trained in the arts of competition, and we're encouraged to articulate and demonstrate success in a particular form that is associated with distinguishing ourselves from our competitors, so making very significant claims as to innovation and first mover status. So early career scholars especially are invited through the doctoral process and beyond to continually articulate their individual competitive distinctiveness and the value that they add and their scholarships adds, so that we're trained in the arts of competition, and we're trained also in many instances, including in Australian universities where I've worked, towards increasing high levels of productivity in particular modes. So competition, but also intense and incessant productivity. And this, I think, really detracts from the life of a university in very significant ways, because universities, of course, depend on all sorts of non-productive work, and on the arts and skills of collaboration, and working with others, which we're not often given an opportunity as academics to cultivate. And this imperative to produce and to continually kind of promote oneself as distinctive and innovative can lead to scholars trying to protect themselves in certain ways, to withdraw from collective and collaborative and unproductive forms of work, just to survive, just to sustain the levels of, and these, I think, these sort of sets of impulses really sap the lifeblood out of teaching and research spaces, and can be counterproductive in very significant ways. And so these are the sorts of challenges that I have uppermost in mind at the moment, and have had for some time. At the same time, I'm really heartened and instructed by all the ways in which scholars, especially early mid-career scholars, are demonstrating the possibilities of working in other ones. So not all sorts of collective projects of writing, reading and publishing, experiments in teaching and co-teaching, and working with students in different formats. And I think I've been to many workshops recently, and including over the last few years, during the COVID times, when people have been trying different formats, different scales, And so I'm constantly learning from all the ways in which colleagues are demonstrating the value and power of collective work, collective reading, writing, and teaching and researching. So there's lots of instances that I can think of where where people don't accept the idea that the only way is to be the competitive, to outcompete one's colleagues.
So I'd like to, to follow up, and the obvious question is to ask you to mention some of those, and the second one would be, what could we do to incentive that kind of engagement? So one of the things, and you put it, very powerfully, and I fully agree. So I was, I wrote a short piece with Sarah Nowen, and it was, in a certain way on the historiographical or the methodological clash between historians and lawyers, and of course many substantive and political disagreements associated with dominating politics in different strands of both disciplines, but also, of course, I mean, in many ways incentivized by neoliberal academia and incentives, and the need to just make sure that everyone keeps their possibilities of engagement. So, and one of the things that I learned from Sarah is that in certain STEM journals, I think in physics journals, you're not allowed to claim to be the first to do X unless you can show it, which is impossible or very difficult. I think I haven't read many physics journals, but it seems difficult. And I thought, I mean, because that's tremendously problematic, right? That's just invisibilizing a whole set of, I mean, to me, it's generally always the case, right? I'm the first to do something. I think, what about X, right? It's offensive. I guess but in certain traditions and certain settings, it's expected. So, so as an editor, I think you could have, for instance, strong policy against this kind of claims. So yeah, that's something that came to mind in terms of something that we could do as editors or jurists to incentivize that. So do you have any other practices in mind? But that's the secondary question to the first question, which is, what kind of projects do you have in mind? I mean, I can think, of these collective projects that you were mentioning. So I can think of law and political economy movement, or lots of pandemic workshops as well. But I want to learn if you have any particular ones in mind, if I'm not putting you on the spot.
Yeah, I mean, when you're talking about editorial work, that's an interesting instance of work that is so significant for the scholarly endeavour, and yet doesn't quite fit the mould of because you have to do that work. Being an exceptional editor is not really something. It's something that everyone values and recognises, but is not really reportable or announceable. And I mean, when you it's relatively rare, but there have been increasingly instances of scholars bringing that to the surface and talking about editorial work. And I've seen this in the pages of Egil about and other kind of relatively mundane work, that low prestige work like book reviewing is something I've thought about as work that's really significant for the scholarly endeavour, and kind of needs to be celebrated and recognised in its distinctiveness, and people experiment with in interesting ways. And sort of review essays, different versions of the review essay, different, but also thinking about editorship and different editorial configurations. I'm privileged to be involved with a number of editorial communities that are kind of exploring the way that this can be reconfigured. So Science, Technology and Human Values is one journal that I'm on the board of, and that's now edited by an editorial collective. And the way that they do things is really quite different to the way in which it's been edited. The journal has been edited in the past, and I see that in other journals with which I'm involved. Editors really reflecting upon the way that interns are involved, the way that various forms of paid and unpaid labour deployed, and really actively bringing to the surface discussion around how we do this. So that's one area that the work of editorial work, and the kind of thought and collective discussion that's going on around that. I feel quite hopeful about that. And of course, we could say, well, you know, open source journals allow new ways of doing that. You know, the publishing industry, one could have a whole discussion on that. But I'm thinking just not necessarily of founding new journals, but just taking existing journals and really thinking about the engine that they have depended upon and ways of reallocating and reconfiguring that
Totally.
workplace.
Yeah, in fact, I mean, the very practice now of just allowing review essays to have their own title and the author as if they were, I mean, recognizing them for what they are, which are academic contributions, and not just, you know, your name is just a small one because someone else wrote the book. So thank you so much.
Yeah, and absolutely. It's interesting actually that law is a particularly anti-collaborative space in legal discipline, because I mean, as an early career scholar, you realize that co-authoring, collaborating kind of detracts from, I mean, the recognized value of this. And I was always wondering why historically that is such a, because it's a really sad story, I find. But yeah, as you notice, I think we could keep talking, and we wish we could keep talking with you longer. But instead, we will just thank you for spending these past 2 days with us on behalf of the EUI, of the Max Weber program, of the Max Weber cohort, and the wider EUI community for giving the Max Weber lecture yesterday, and also offering a masterclass this morning. And yeah, before we conclude, I was wondering whether you had a final message that you wanted to share with the audience, or some final thoughts.
Just to say thank you. It's been an absolute pleasure, and the discussions have been really rich. I've learned a lot. And so thank you so much for having me and for our conversation now.
Thank you so much. It's been a huge privilege.
Yeah, thank you once again. It was a huge pleasure.